All right. Good morning and welcome inside the law. I'm your host, Philip Holloway. This is a special edition. We have the Georgia State Senate let's see, they're investigating Fani Willis, Fulton County's district attorney. In just a few minutes, I'm going to hopefully, if he's able to make it in here, Vice Chairman of the Senate Committee, Senator Greg Dolezal, says he might pop in at around, I don't know, around 52 minutes after the hour, just a few minutes before the hearing. So I started a few minutes early because I wanted to, um, just have a minute to welcome everybody in and see what's going in the chat. And I'm going to show you what the agenda is for today's hearing. All right. And I'm going to remove sound. All right. Anyway, um, welcome to everyone that's here. You don't have sound. Let me see what's going on. Bear with me. That's on. This is on. This is on. All right. Let's do a reset. And we're back. Someone was saying we don't have sound, so I resetted everything. It looks like everything is fine, and I'm now seeing reports in the chat that we have sound. I don't know what happened, but anyway, welcome back inside the law. This, of course, is the YouTube channel where we take you inside the real justice system, and sometimes the justice system has ancillary matters such as the hearing that is set to take place here by the Georgia Senate. I'm going to be, let's see, I'm going to share the screen here. We're going to have the page where the Georgia Senate Committee is going to be hopefully shortly starting their presentation. Looks like they are still not quite ready to start, but when they start, we will see it right here. Again, I showed you before I had to restart the browser here to make sure we had sound. We have the actual agenda for the day, which of course includes Fani Willis herself. She's being investigated. This is the Senate hearing, by the way. This is the same Senate panel that you've heard for. You heard Ashley Merchant testify. I think she was one of the first witnesses. We had also the chairman of the county commission talking about their budgeting process, and the committee is, I'm told, ready to try to finish up their work, but they need to hear from Willis herself. Now, she's represented by former Georgia governor and attorney Roy Barnes, who has filed a motion to quash the subpoena. Now, interestingly enough, we have had all of the it was filed in Fulton County Superior Court. And so all of the judges, of course, in Fulton County have recused themselves from hearing that motion, and it has not been reassigned. So as we sit here right now, as we talk, this subpoena is valid. This subpoena is valid, and we don't know. We have reports that she's not going to show up, and I've also heard reports that she may show up and refuse to answer questions. And I've also heard reports that her attorney may try to appear in her stead. So with that, we will just have to wait and see. Now, here in any minute now, and this is a definite maybe. I'm hoping here in just a moment or two before the hearing starts, I'm hoping to be joined by Vice Chairman of this committee, Senator Greg Dolezal, who can tell us what this is all about. That's why I started a few minutes earlier than the advertised start time of 9:50. It's now 9:52. This is about the time he said he would try to pop in. But of course, he has a very limited time window. He's going to be participating in this hearing. And so if he has time and he's able to pop in, I will get him in and let him tell you what this is all about from his perspective. But I'm not 100% sure he's going to have time to make it. We certainly hope that he is. All right. So welcome to, I see 1,000 people in here live. I appreciate every one of you being here inside the law. This is obviously something that this channel and others have been following. And at the end of the show, or when the committee hearing is getting ready to adjourn, I plan to have a question and answer. Of course, if there's any breaks, we can do Q&As then. I don't have any. I have some moderators in the chat. I don't have any that are logged into my screen where they can mark or star, if you will, the questions. So things that will help you is if you ask a question, preface it with the word question. That helps me see it. And of course, super chats automatically get starred, and they are put in a special place on my screen so that I can see those, and will do my best to answer and address all questions and comments, particularly the supers. Those are easy for me to see. They pop up, and we will I'll do my best to get to all the questions and answers that I possibly can get to at the end. So with that said, I see that the chat is very, very active. I see that a lot of people have perhaps popped over from what's going on in the YSL trial this morning. It's a non-jury day, so that's, there's not going to be any testimony. All right, here we have, I want to go ahead and I see Senator Dolezal. I'm going to go ahead and bring you in. I'd like to welcome to Inside the Law, everyone, Georgia State Senator and Vice Chairman of this committee, Senator Greg Dolezal. Good morning, Senator. Can you hear me?
I can, Phil. Can you hear me? Good morning to you as well.
You're doing great, loud and clear. I know your time is limited, Senator. So we have 1,382 people in here that are waiting to hear from you to tell us what today is all about and what you expect to happen and why it's important for you to hear from Fani Willis herself.
Yeah, so today was originally, and hopefully still is about, maybe she'll have a change of heart and honor the subpoena that was duly issued under the authority provided to the legislature and the Georgia Constitution that we enshrined. Phil, as you know, I was the lead sponsor of the resolution that formed this committee. We did significant research with legislative counsel to ensure that the subpoena power and the swearing in under oath that the authority we gave this committee in that resolution complied with Georgia law and the Constitution. But it appears that the district attorney who took an oath to uphold the law believes she's above it. And I find that ironic because she subpoenaed a whole heck of a lot of people to appear before her in her time. And we have done the same thing because we want to get to the bottom of two different things. One is this question of prosecution for personal profit and the use of state funds, as has been alleged, to carry out this case. And then secondly, figure out what Georgia laws may need to be changed as a result of what we've learned through this case as we've watched it happen from just down the street here.
So in addition to her testimony, which obviously is important, what else have you subpoenaed? Documents, records, what?
Yeah, so Chairman Cowser subpoenaed a number of documents, a number of records. We have received additional documents and records that we hope to be able to ask about today. That some things have come to light even within the last couple of weeks around specifically the use of funds that I don't want to go into any detail on, but that we intend to ask her about if she arrives today. And then certain things as it relates to other things that, within the office that we've heard previous testimony about. But we've received no documents as a result of our subpoena. We read in the AJC yesterday that the DA would not be appearing today as well.
Well, we'll certainly see, and we'd love to see her, of course. I think it's important that she does answer these questions. There's no doubt in my mind you have the authority. I know that former Governor Barnes, who is her legal representative, he's filed a motion to quash the subpoena, and I understand all the Fulton County judges have recused themselves. And so we'll be watching for any developments on that. As of right now, though, her subpoena has been lawfully issued. It's been served, and if she doesn't show up, in my opinion, she's violating the law. So for someone who says everyone is above the law, I'll leave it to everybody else to decide if she's acting like that is the case.
Yeah, we're going to hear this morning, Phil, from the former Secretary of the Senate, David Cook, as well as our legislative counsel, who are going to walk through the specifics of the law. So I know that your viewers are legal junkies and well informed on the law as you are. You've been doing yeoman's work on this issue. First of all, I want to thank you for the way that you've been out front and informing the public as to what's going on. But there's going to be a lot of good information that's going to come even in her absence, a lot of good information for the public. So I'm going to go ahead and walk across the hall because we're adjourning in just a few minutes here. But thanks for having me on. And once again, thanks for the good work you've been doing.
You bet, Senator, and you're welcome here anytime inside the law. We'll see you in the hearing room.
Sounds good.
All right, there you have it. That is the Vice Chairman, Senator Greg Dolezal, who, he was the person who he sponsored and I think maybe wrote the legislation that set up this hearing. And he's not the chairman, but if I had to point to anybody who's responsible for this investigation even taking place in the first place, it's that guy right there. He literally wrote the bill that set up this process. And he has been. He said, I'm doing yeoman's work, but I think he's the one who's been doing a lot of great work to try to get to the bottom of this. So appreciate him taking the time to come in. I have 9:58 local time here in Atlanta. The hearing is supposed to start in 2 minutes. And when that happens, you'll hear me shut up. I might, if appropriate, I might weigh in with some comments here and there. I will try not to be disruptive. And at the end, for those of you who are just joining us, I plan to do a question and answer. If you can phrase your question in the chat in the form of a question, it helps me see it. Of course, super chats get automatically starred, and I am able to easily identify those. But I will do my best at the end or at the break, if there's a break. We don't know how long this is going to go, but I'll do my best to try to answer any questions. And by the way, since we got about a minute, I'm going to be doing this weekend, maybe Saturday, maybe Sunday. I'm not sure yet. I'm going to go through and review the order from Judge Scott McAfee that tossed 3 counts of the Fani Willis RICO indictment against former President Trump and others. I'm going to be breaking down that order. We're going to be talking about what it means. So be on the lookout for a notification. If you haven't subscribed, go ahead and subscribe inside the law here. I'm almost at 50,000 subscribers. That's my next benchmark I'm trying to hit. So if you see that So if you want to get notifications, you want to know exactly when that's scheduled. If you haven't subscribed, please subscribe and allow notifications. So as soon as I fully digest that document, I'm going to do a live stream here, and we will talk all about the document. All right. So I'm going to just make sure I'm going to refresh this over here to make sure we're not, still haven't missed anything. They haven't started, although it looks like we might be close. So I'm going to just leave it right there so we won't miss 1 minute. It's 10 o'clock sharp. That's when the committee is set to start. In the past, they've started right on time or maybe a couple of minutes late, but we should be going here any moment. The big question is, will Fani Willis show up or will she dodge her subpoena? I know what I'm betting on, but I've heard that she's not going to show. I've heard that she might show. I've heard that she might show and not answer any questions and basically give them the finger, not literally, of course, but I've also heard that maybe her attorney will show and try to make some statement or argument to this committee. I know Mr. Barnes, former Governor Barnes, her lawyer, has been in attendance at prior hearings. I think he was there when the chairman of the Fulton County Commission testified. And I think he might have even been there when Ashley Merchant testified. The hearing is now 1 minute late, but that's fine. That's to be expected. Nothing in government or courts, for that matter, tends to start exactly on time. I remember one of the earlier hearings, they had a committee member that got stuck in traffic. And if any of you are familiar with Atlanta traffic, that makes completely perfect sense. And so they had to start a little late. I just got a very, very interesting text message from Ashley Merchant. But it's going to be followed up by something else. And I don't know what it is. If I can share it with you, I will. But I invited Ashley to make a cameo in here if she's able. I think she's probably not able, but of course she's welcome. And she and I were talking the other day, actually in around the courthouse, and we are talking about doing something together. She's got some oral arguments coming up soon on a case that she was involved in years, where she defended someone who was acquitted of murder in a high profile cold case out of South Georgia. For those of you who might be familiar, it was the murder trial involving the death of former Georgia beauty queen Tara Grinstead. There's some appeals now for a related indictment that she's arguing coming up this month, and we might do a live stream about that. But she's also talked about doing a preview of the argument that is expected in December related to the disqualification of Fani Willis. That, of course, coming up in September. All right. We are now 3 minutes past the hour of 10 a.m. here local time in Atlanta. For those of you who are just joining us here inside the law, welcome. We have, looks like 2,660. If you hadn't hit the like button, please like, and of course, subscribe. We're trying to get to 50,000 subscribers. That's my next goal. At the end of the hearing today, I'm going to do my best to answer any questions that pop up. For example, this is how, I automatically see super chats like this. So can Fani be held in contempt? That's a great question, and one that I want to dive into there at the end. And of course, Great Grandma Anonymous, can Fani be arrested? Same kind of question if she doesn't show up. We might hear some testimony about that. So we're going to hold these questions, and I'm going to come back and revisit them at the end. And by the way, of course, as always, thanks for those super chats, guys. That's what helps me continue to bring this content to you. It goes directly to support production costs. Speaking of production, my chief executive producer, Winston, whose picture is over my shoulder here, he's laying at my feet, and I expect him to say hello just as soon as he hears any movement elsewhere in the building, you'll hear from him. So I apologize in advance if he says hello in the only way he knows how. He has a very deep voice, this Winston does. All right. Looks like the Senate is, I'm trying to send a text message to someone who's supposed to be in the room. I'm trying to find out the nature of the delay. I really enjoy watching these things together with the insiders here inside the law. One of the things I don't like is when things don't start on time. And so I have to fill the time by talking and basically ad-libbing. So if anybody has any question that want me to try to address that I can get into, I'm happy to do that. I see we have 2,735 people. Welcome to all of you. Please hit the like button. I know I saw some interesting comments and questions. By the way, I want to give a special thanks to, I know one of our moderators, Kiana Shaw, is here. Thank you for moderating in the chat, Kiana. I really appreciate it. And I'm not in the right screen where I can easily see moderators, but if I have any others in here, I appreciate you guys. We have a handful of great mods here inside the law, who we really, really appreciate. Yep, Transplanted Texan is one of our mods, and I expect Transplanted Texan to be back in the very near future. So, but Transplanted Texan is, of course, always missed. What is my Carly says, what's my honest prediction on Fani Willis outcomes? I think she's going to be disqualified. I think that I did a stream on this where I went and looked at the judges on the appeals panel for the Georgia Court of Appeals. You can go back and find that. I don't have time to send you a link right now, but I did a live stream where I looked at those judges and I looked at, what based on who they were and what the arguments are, what I predicted. And I predicted Willis is ultimately going to be disqualified. Now, if that happens, thank you, Carly, for the super chat, and thanks for the question. If that happens, there can be an appeal from the Court of Appeals. They could ask the Georgia Supreme Court to overrule that as well. I'm looking in on the Georgia State Senate. Let's refresh this. Looks like they've started the stream, but they don't have any activity in here as of right now. Okay. Let me reload one other screen where I was looking for the stream. I just want to make sure that bear with me, guys. Want to make sure we don't miss any seconds of it. All right. This was I remember from last time. This was one of those. This was one of those streams that was. It was hard to be certain that it had started. I need to refresh the browser. So anyway, it was supposed to start 9 minutes ago. For those of you who are just joining, we had about 10 minutes ago, 10 or 12 minutes ago now, we had the vice chairman joining us live here inside the law, telling us the expectations and why it was important to hear from Fani Willis herself, as well as look at the documents. And that would include, I think, emails and text messages related to the hiring of Nathan Wade and other things involving him. They really want to get to the bottom of this. What I expect to happen, the reason this is important, and this is a good thing to talk about, the reason this hearing is important, the Senate, of course, can't take any direct action. They can't prosecute somebody. They're not law enforcement. But what they can do what they can do is pass laws. The legislature can create laws that will rein in how district attorneys use special prosecutors, if at all, and they can pass other laws that they deem as appropriate to monitor the budgeting process, the spending process, and unless or until they do that.
Quorum this morning, I will call to order Senate Special Investigative Committee. We have
Here we go.
Full agenda this morning. We have first, we need to approve our minutes from the last minute, and then we have subpoenaed Fani Willis to testify. According to press reports, she is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses and issuing subpoenas. So we are guided by their work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee, as well as our subpoena powers. Following that, Mr. David Cook, our former Secretary of the Senate, who's been very involved guiding this committee through the process, will give us some insights from his expertise in legislative procedures and the authority for legislative investigations, the rules that govern legislative processes, and these gentlemen will both be available for questions if we may have them as they try to inform us of our legal standing. So I'll wait just a minute, let everybody take a look at the minutes. We actually have two different meetings that we needed to approve the minutes. We lost our quorum last time. I'd want to start with the May 23rd meeting. If anybody just has any questions about that, just take a look and it'll remind you what we've been doing. I was surprised to see in the press that this is our 6th meeting of the committee. It seems like they're moving pretty quickly as we've been in action since back during the legislative session. I expect we will have 2 or 3 more meetings this fall, and we are continuing to get information from members of the public that have concerns and questions and proposed testimony. So we'll have plenty to do as we complete our mission of investigating some of the alleged misconduct and also ways to improve our statutory authority and laws that govern some of the areas that we've heard testimony on. Everything from special grand juries to special prosecutors to funding aspects of district attorneys' offices and accountability for the expenditure of public funds. Those type of things we'll all look at before we come up with final recommendations of the committee. Having reviewed these minutes, is there a motion to approve the minutes from the May 23rd meeting?
Mr. Chairman,
Yes.
I wanted to just make a comment.
Hang on one second.
I was not
Mr.
present.
Leader.
Okay. I was not present physically at the meetings, but I did participate online. There was not a Zoom function, but I listened to it. And so since questions weren't asked, I feel like I wanted to make that be put on the record. But with that being said, I would make a motion to approve the minutes as presented.
Was there one particular thing about the May 23rd meetings you had a question with?
No, sir. No,
Questions not being asked?
no,
Okay.
this time, but you did a good job as always.
Well, I appreciate you participating by online with us. I recognize we have very busy schedules and lots of travel in the off season. So we're trying to announce these in far in advance as we
Guys,
can.
it looks like that might be Roy Barnes in the gray jacket, sort of with the gray hair with his back turned to us in the audience, but I'm not sure. It kind of looks like
circumstances, but I was trying to get here, maybe got caught in traffic, but I too was listening in as well.
Well, we wrote you down as arrived at 2:57. You were tardy.
I was
So
tardy.
We
I know I
you
got
were
here,
participating.
but I was doing what I could to get here and listening on the way.
That particular meeting on May 23rd, we started at, we were planning to start at 2 in the afternoon.
That sure looks like
we knew we had
Fani
some travel
Willis's
problems.
lawyer,
Thank
former
you for
Georgia
your
Governor Roy
efforts.
Barnes.
Yes, sir.
All right. Any other discussion? Is there a motion? We have a motion to approve and a second by Senator Dolezal. Any further discussion on the minutes of the May 23rd meeting? All right, all in favor of approving the meetings, vote aye.
Aye.
Any opposed? All right, same thing now on the August 9th meeting, which was our last meeting. If anybody has questions about these proposed minutes.
Motion to approve.
All right, so again, we have a motion to approve. Is there a second?
Second.
Second by Senator Dolezal. Any discussion on these? All right, all in favor, say aye. Any opposed? All right, they are unanimously approved. We are also joined today by Mr. Josh Belafonte, who as legal counsel has been retained by the committee to represent our interest in certain litigation that it's already really been filed, but it's more to come, I think, in the enforcement of subpoenas before this committee. I will expect that at the conclusion of the public portions of this meeting and the public testimony, we may go into executive session to have him.
That means they've
under
got
our
their
attorney-client
lawyer
privilege
because
advise
they
us
have
as to the
litigation
current
now filed by
status of
Fani
any
Willis
pending,
herself to quash the
litigation.
subpoena. So they've got their
All
own
right, at
lawyer
this time,
representing the
then I
committee.
want to have Mr. Stuart Morelli introduce himself and just give us an update on the sort of the legislative process here, the investigative powers of our branch of government and the ability to have witnesses to testify under oath and our issuance of subpoenas. As a member of the Legislative Council's office, you're assigned to this committee, and we appreciate your efforts in helping us behind the scenes be prepared and follow the appropriate procedures up until this date. And you shared with me this memo that was really, it's 13 or 14 pages long that was prepared some years ago by your office. If you would just kind of give us a general overview of the research and work that you've done and the big scope of things, the legislative investigative powers.
Yes, sir. So, as the chairman said, I believe each of you have a copy of the 2016. I've always called it a manual, whether you call it a manual or a memo. It is the research our office conducted some 8 years ago in outlining the legislative investigative powers, including the abilities to issue subpoenas and compel witnesses to attend. When you're looking through that, you'll notice that a number of citations go back to, of course, Mason's Manual on Legislative Procedures, which I may also be, referencing, in my presentation today. Mason's does a very good job of, outlining the various the powers of legislative bodies as well as the procedures in them, and cites to, case law in states to support its positions. So as a general matter, it has been found almost universally by the various courts that have looked at the matter, including the United States Supreme Court and Supreme Courts in our sister states, that all legislative bodies have an inherent power to conduct investigations. As the Supreme Court reaffirmed, the United States Supreme Court reaffirmed in 2020, that power is inherent to the legislative process, as in it does not have to arise from a specific grant of statutory or constitutional authority.
This 2020 case would not have been in the 2016.
No, sir. And I'm going to provide some, that information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazars case, Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927 case in McGann. The Mazars case then went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently. As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations, going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I am aware of was stated by Justice Thomas in the Mazars case. He did believe that that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided, but no other justices joined in that opinion. Other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature. I will.
Was that an 8-1 decision then? Or?
Justice Alito dissented on different grounds. He did not join Justice Thomas's dissent, so it was 7-2.
Okay.
And just for the record, the Georgia Supreme Court has never addressed legislative investigations. It just has not been an issue that has made its way to the Georgia Supreme Court. So it does appear that there is virtually no case law directly on the ability of the General Assembly to carry out or to compel testimony and compel witnesses to appear before it and to produce documents. In addition to the near universal finding that legislative bodies have an inherent power, it has also been the near universal finding of the U.S. Supreme Court and other state Supreme Courts that the power to investigate is not only possessed by the entire legislative body, but also by its constituent chambers, and that those powers can be exercised by one chamber on their own. So bicameralism has never been found to be necessary to carry out an investigation, to compel testimony for a full chamber of a legislative body. And also, the courts have universally, when the issue has come before them, held that a legislative chamber is fully within its right to delegate its legislative investigative powers to a committee, including the power to compel testimony and subpoena documents. However, the case law is also clear that absent such an affirmative delegation, a committee does not on its own have any inherent power to conduct investigations. And the investigatory powers of a committee are limited to those that are specifically granted to it by its parent body. One area in which there is not a universal holding when it comes to legislative investigative powers would come to the ability of a legislative body or a committee of a legislative body to conduct its hearings and to compel testimony once the legislative body has adjourned sine die. There is a conflict between the state courts that have interpreted this matter. Some state courts find that it is perfectly fine for a subcommittee or for a committee to compel testimony after the parent body has adjourned sine die. Some Supreme Courts have found that it would require a joint resolution of both chambers of a legislative body to allow that to happen, finding that once the General Assembly had adjourned sine die, there would need to be some level of bicameralism for the investigative powers to be conducted. And some state Supreme Courts have held that such investigations are completely prohibited, based upon the rationale that since the investigative powers are auxiliary to the legislative power, and since a legislature cannot legislate once it is adjourned sine die, then the auxiliary power itself would disappear. Luckily, here in Georgia, we do have a constitutional provision that addresses the ability of the General Assembly to establish interim committees. Article 3, Section 4, Paragraph 4 of the state constitution provides that each house shall determine its rules and procedures and may provide for its employees. Interim committees may be created by or pursuant to the authority of the General Assembly or of either house. So the people of the state of Georgia have empowered each chamber of the General Assembly to establish interim committees as they so choose.
Let me hold up just to make sure we all understand this then. In the state of Georgia, it is in the Constitution that each body, the House and the Senate, may establish committees that's work may continue after sine die.
Yes, sir.
Okay. And so any of these other states that have varying decisions would be based on their statutory law and their constitutions.
Yes, sir. That is correct.
No Georgia court has ever held that our legislature doesn't have the authority to meet in the off season, as many of us call it, but when we're not in legislative session.
Yes, sir. That is correct.
That's why we have all these study committees that meet every year that are investigating and trying to find solutions to problems and formulate legislation.
Yes, sir.
Okay. And as far as you're concerned, does that constitutional provision also apply to investigative authorities as set forth by Senate resolution? Make sure I remember the number here. We have this in the folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well. It would seem to be it would seem to be limiting the power of it would just, seem inconclusive that why an interim committee could meet, but a standing committee would not, when the Constitution has authorized a type of committee to meet in the interim.
Your legal opinion that we are authorized to meet in the interim
Yes,
by the Georgia Constitution. How about under Senate Resolution 465? Does it specify that we are permitted to continue our meetings after sine die?
I don't believe it specifically states that, but it also, unlike the resolutions that would tend to create study committees, does not provide a end date for the committee. A typical resolution committee, a study committee, talks about how those study committees tend to stand dissolved as of typically December 1st of the year they were created, absent any type of explicit date stating when the committee dissolves. The resolution would appear to indicate that this committee has the authority to continue to operate until the 158th General Assembly is sworn in. This being the 157th General Assembly.
Okay. I apologize for my interruptions, but I didn't want to forget them. So back to your presentation.
So, and this is kind of along the lines of, in addition to the constitutional provision, while there has not been any case law that addresses the ability of the General Assembly to conduct investigations, there have been, on as far as I can tell, 4 occasions where the General Assembly or a chamber has created a committee to conduct investigations and to study the affairs of the state. And in all 4 of those situations, it does appear that those committees did carry out their powers once the General Assembly adjourned sine die. I would say the clearest example of this authority comes from 1871 with joint resolutions 7, 9, and 12 of the General Assembly. Both of those, again, were adopted by both the House and the Senate. They established various joint committees to investigate the issues arising of former Governor Rufus Bullock's administration. These resolutions specifically granted to those investigative committees the power to compel witnesses and subpoena documents. Then in 1896, the House of Representatives, and through a resolution, established a committee to investigate each department of the state government. The resolution was adopted on the day that the General Assembly adjourned sine die, so there was no way that committee could have carried out its functions during the session. Based upon the House journals, it does appear that committee did conduct extensive investigations in the interim in 1896. In 1897, the committee filed its report with the House, and the committee report and the minority report go on for about 86 pages. They provide a very in-depth, detailed examination of the affairs and operations of the various state departments. This committee apparently went to the offices of each state executive officer, inspected their books, investigated their practices. There is a in-depth discussion of the ability of the affairs of the Department of Agriculture at the time. It appears that the committee questioned the best practices the Department of Agriculture was carrying, not only in bookkeeping, but in contracting with various contractors. I believe it was to provide tags for seed oil. not being an agricultural guy, I don't completely understand that. They also, there are references in the committee report to how they visited each of the state's hospitals at the time, commenting on even when they went to the school for the blind, that the dormitory for one set of students, the boiler room was lacking adequate insulation around the boilers. So it was a very in-depth review, digging into the details and operations of the various departments of the state executive branch. And again, making comments on their bookkeeping, making statements on how much funds they had. The committee made a number of recommendations, both for potential legislation to address matters that they saw, as well as to recommendations on future appropriations, whether to increase or decrease the set levels that had been given to the various state agencies. I will note that the 1896 resolution by the House does not state that it grants the committee the power to compel witnesses, but as I said, they undertook an extensive investigation. The report makes no indication of whether or not the executive branch objected. So I cannot speak to whether or not they were forced in some manner to get the executive to comply, but the report is silent as to that matter. And then finally, at least in the past 100 years, we're getting up to, in the 1964 special session, the Senate adopted Senate Resolution 30, which established an interim committee to make a comprehensive inquiry into the Stone Mountain Memorial Association. I just discovered this resolution last night and was unable to get my hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial Association also was silent as to whether or not it delegated the power to compel witnesses. I was able to see that a number of bills were proposed and adopted in the 1965 General Assembly, revising various provisions of the law governing the Stone Mountain Association. So I would make the assumption that the committee did make some recommendations that led to that legislation. Enforcement of legislative subpoenas has also been a matter that the courts have been forced to address throughout the history of the United States. Going back to 1821, the United States Supreme Court in the Anderson v. Dunn case did find that each House of Congress did have the inherent power of contempt. In that case was a case where a gentleman was detained by the Sergeant of Arms of the House, and he had sued under habeas corpus to get his release. And the Supreme Court did uphold the finding, the Federal House of Representatives finding of contempt, the power to find him in contempt for refusing to come testify before them. In addition to the inherent power of contempt that most courts have found that legislative bodies have, judicial enforcement of subpoenas has kind of been the more modern practice if a state has not adopted a specific statutory procedure for enforcing its subpoenas. There are some states, like New Jersey, for example, has a very detailed provision for the enforcement of legislative subpoenas that ultimately can result in a person being held in criminal contempt if they fail to abide by a subpoena. In Georgia, we do have a couple of statutes on the books that do provide some degree of guidance for judicial enforcement of legislative subpoenas. One that I will not spend a lot of time addressing, nor does the manual, are the provisions in Title 28 regarding the House and Senate ethics committees. Those are really much more designed to carry out ethics investigations into members of the General Assembly themselves. Of course, we can get into that if anyone wants, but they are not, those provisions don't seem particularly pertinent to the present committee. In addition to those provisions, there are the provisions of OCGA 48-15-17 and 45-15-17 and 45-15-19. OCGA 45-15-17 provides the authority to the Attorney General to conduct investigations into the affairs of the state, and does now provide procedures by which the Attorney General can compel people to appear before his or her investigations, subpoenaing those witnesses and subpoenaing documents as part of those investigations. In the event that the Attorney General is forced to enforce, if somebody refuses to comply with one of the Attorney General's subpoenas, the code provides that the Attorney General has the ability to go to the Superior Court of the county where the person to whom the subpoena was directed resides to seek judicial enforcement. OCGA 48-15-19 grants both the governor and the General Assembly the exact same authorities that are granted to the Attorney General in 48-15-19. While these statutory provisions do exist both in 48-15, both in Title 45 and in Title 18, they in no way override the General Assembly's inherent authority to conduct investigations, or its inherent authority to carry out contempt procedures, or its inherent authority to attempt to enforce its subpoenas. Article 3, Section 6, Paragraph 3 of the state constitution provides that the General Assembly shall not abridge its powers under this constitution. No law enacted by the General Assembly shall be construed to limit its powers. Therefore, the provisions of Title 45 and Title 28 are not limitations upon the General Assembly's power. They are additions to its inherent power, and have probably been enacted to provide some guidance to the judiciary if the General Assembly is ever in need of its assistance in enforcing its subpoenas. Absent some sort of statutory provisions for the courts to refer back to, it would appear, and this has been the case in some of the older case law from other states, is that the courts are then forced to resolve disputes into legislative subpoenas using their equitable powers. So it just, at that point, it gets much more complicated for the courts to determine those matters absent some sort of statutory guidance provided. One area that is not addressed in the manual, but I felt needed some updating, especially in light of the Mazars case, are questions regarding separation of powers. And the Mazars case does lay out that courts, when considering legislative subpoenas, in certain cases in Mazars' case, the president, need to show some heightened concerns to recognize the separation of powers. However, one thing that the Mazars case is very clear about is that it is limited to issues regarding congressional subpoenas to the President of the United States. As the Mazars court says, the president is the only person who alone composes a branch of government. It goes on to state, the interest of the man is often connected with his constitutional rights of his place. A balanced approach is necessary, one that takes a considerable impression from the practices of government. Courts must perform a careful analysis to take adequate account of the separation of powers principles at stake, including both the significant legislative interests of Congress and the, quote, unique position, unquote, of the president. So it would appear that the Supreme Court in the Mazars case, when they're setting these heightened standards of separation of powers, is designing that to specifically address the unique arrangement in the federal constitution where the president is the executive branch under, I believe, what is generally called the unitary executive theory. Two state Supreme Courts, as far as I'm aware, well, two state appellate courts have addressed the Mazars case and how it applies to state separation of powers issue. The first court case was the Montana Supreme Court, and I can give you all the citation for that case if you give me a second. Sorry, there we go. McLaughlin v. Montana State Legislature. In that case, the Montana legislature had subpoenaed the court administrator to request all emails that the court administrator had with the various judges of the Montana judicial branch to investigate whether apparently the Montana legislature had been considering some legislation regarding, I think, judicial compensation or some such. The judges circulated a poll amongst themselves, and the legislature was interested in the results of that poll. Ultimately, the Attorney General of Montana, challenged legislative subpoenas, and the Montana Supreme Court did find that separation of powers in that case did require, and citing favorably to the Mazars case, that the legislature had exceeded its authority. Ultimately, the Montana Supreme Court found that Montana, similar to Georgia, has a procedure for judicial punishment, and that the alleged purpose of the subpoena was to investigate whether or not the judges had complied with the Open Records Act. And the Montana Supreme Court determined that that was not a function of the legislature, since there was an established procedure for the punishment of judges. The Montana Supreme Court found that the resolution setting out, or the subpoena issued by, it was, I believe, the Standing Judicial Committee of the state Senate there, did not properly detail a legislative purpose beyond seeking to see if the judges had complied with their Open Records Act. The other state appellate court that has addressed the Mazars case would be the Commonwealth Court of Pennsylvania, which I believe is their intermediate appeals court. The Pennsylvania Commonwealth Court in Costa v. Ward found that Mazars was not applicable to an issue arising when the Assistant Secretary of State of Pennsylvania attempted to quash subpoenas issued by their state Senate. The Costa Court, the Pennsylvania court, did find that the Mazars case was limited in scope to the specific unique role that the president has in the federal system. However, we also have a Georgia case, which is not directly on point, but it does address the issue of separation of powers when it comes to governmental investigations. In 1975, the Supreme Court issued an opinion in Dean v. Bolton. In the Dean case, the lieutenant governor had requested the governor to request the attorney general to conduct an investigation into the travel and expense accounts of a state senator. That investigation was conducted under the previous version of OCGA 48-15-17, it occurring before the OCGA was codified in 1983. I don't have the specific site. The language, though, the statutory language had not significantly changed in that, in that period of time. The senator challenged the investigation on the grounds of the state's separation of powers clause, constitutional separation of powers. The Georgia Supreme Court went on to provide, let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. So,
but hold on right there. That sounds directly on point, if you ask me.
It was not directly arising out of a legislative subpoena. It is directly on point to the statutory provisions that the General Assembly has and were cited to in the resolution establishing this committee.
And those are the same statutory provisions recited in our resolution forming this committee?
Yes, sir.
Or their predecessors?
Yes, sir.
Would you give me the citation to that case?
Yes, sir. I'm sorry. I've been a bad attorney and not giving you the cites.
You got a whole bunch of attorneys on here, and you got a couple of non-attorneys that are as smart as.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544, and again, it was a 1975 case.
Yeah, all right, so that's Dean versus Bolton. Yes. 235 Georgia 544.
Yes, sir.
All right, so would you read that holding one more time? Because it sounded like it said that the executive branch, Attorney General in that case, did have the authority to subpoena records concerning improper conduct in office of a state senator, dealing
sir.
with the travel and expense reimbursements.
Yes, sir.
And that same code section that gives the Attorney General that authority is what we're traveling under here, that gives the same powers that the Attorney General has to the state legislature.
Yes, sir.
Am I right?
Yes, sir.
Would you read the holding that you just read us again?
Yes, sir.
Okay, thank you.
Let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations.
Okay, so what we're doing is constitutional.
Under the Dean holding, it would appear so, yes,
And
sir.
that's a holding that's interpreting the Georgia Constitution.
Yes, sir.
And our separation of powers allows the legislative branch to investigate other branches of government, other individuals and their conduct in office.
That is that is definitely what can be taken from the Dean opinion. Yes, sir.
Pretty much
well
the
as the
clear
inherent.
wording of it.
Yes, sir.
Okay. And that was the factual scenario in that case, was looking into the conduct in office of a state senator.
Yes, sir.
All right. That's the only Georgia Supreme Court case dealing with this separation of powers, whether the legislative branch can investigate.
Yes, sir.
Okay.
As far as it was the only one that I found.
Still good law now.
Yes, sir.
And there's no constitutional provision that has been changed that would change the circumstances from 1975 until today.
No, sir. I believe the separation of powers provision of the 1945 Constitution was carried over verbatim into the 1976 and 1983 Constitutions. The only potential relevant change is, of course, the addition I talked about interim committees, which was apparently an addition in the 1983 Constitution.
And that 1983 Constitution is the current version of the Georgia Constitution.
Yes, sir.
Okay. All right. So before you veer.
Well, I have now reached the end of my prepared
Okay.
notes.
We're going to get some more out of you then. Back to the United States Supreme Court. Of course, that applies nationwide, right? Those holdings.
Those holdings apply to the federal government because it is interpreting the provisions of the federal Constitution as it applies to the Congress's power. Those opinions are not binding precedent on the states, but have largely been taken as authoritative precedent. But, as I, said when my discussion about the Pennsylvania court did not accept Mazars as binding precedent, whereas even the Montana Supreme Court, when the state Senate asked for a motion on rehearing, the Montana Supreme Court in their petition to deny rehearing did state that they were citing Mazars only as authoritative precedent, but in no way claiming that it was binding precedent upon the state of Montana.
So when we talk about the idea of legislative oversight, legislative investigations on the federal level, there's a line of Supreme Court cases that say this is an implicit or inherent power of the legislative branch, that you have the power in order to do your job of passing laws in the public interest, creating public policy. You occasionally have to investigate. Similar to when our committees meet during session, we routinely have hearings and have presentations by the author of a bill and any other interested citizens giving pros and cons of the bill, right? And that's necessary for the legislature to do this investigation, to do their legislative duties.
Yeah, yes, sir. The general view is that the investigative power has to be inherent to the legislative process because, again, as the Supreme Court recited in the Mazars case, without information, a legislative body cannot properly legislate, as I believe the Supreme Court, U.S. Supreme Court said they'd be legislating in the dark.
Very similar to probably the seminal United States Supreme case creating judicial review, Marbury versus Madison. All the lawyers on this panel, they graduated law school, so they know that one. The United States Constitution never says the United States Supreme Court has the power to strike down a law as being unconstitutional. But
Correct.
they stated that power because it was implicit, inherent. Otherwise, you're a ineffective branch of government as the judicial branch if you don't have that inherent power to set the rules, what is and is not constitutional, right?
Yes, sir.
Same type of principle here on legislative investigations, that is an inherent legislative authority, whether the U.S. Constitution says it or not.
Yes, sir. And
But the Supreme Court, it says they got it,
yes, sir.
even though it's not articulated in the Constitution.
Yes, sir. In
Any
fact,
reason that should be different at the state level?
no, sir. In fact, some of these, what I've seen in some of these state Supreme Court rulings is they find that that inherent authority can also be justified under a separation of powers because absent, the ability of the legislature to investigate on its own, would be highly dependent on information provided to it by the executive.
So even if Georgia's Constitution did not give an investigative power to the legislature, it would be implicit if in keeping with the United States Supreme Court's interpretation of the separation of powers.
Yes, sir. Yes, sir.
And the provision you read out of the Georgia Constitution, does it essentially give us that constitutional authority?
The state constitution does not give an explicit power to it and to conduct investigations. It does specifically authorize the provision I cited specifically gives the General Assembly and its chambers to establish interim committees to conduct, activity once they've adjourned sine die. Since the General Assembly cannot legislate post sine die, really the only activity those committees could take would be studying or investigating.
And that's what we're doing, studying and investigating here. The Dean versus Bolton case was a Georgia Supreme Court that says the legislature does have investigative powers.
Yes, sir.
Okay. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations that the legislature has an inherent ability, power, authority to investigate.
Not in so many words, but I would say that your statement is correct.
Okay. And this committee, in our resolution that formed us, and I'm going back to Senate Resolution 465, says at line 81, section 4 here, the chairperson shall call all meetings of the committee. Committee may conduct such meetings at such places and at such times as it may deem necessary or convenient to enable it to exercise fully and effectively its powers, perform its duties, and accomplish the objectives and purposes of this resolution. That in no way limits the meetings to just during the legislative session, does it?
I do not read any specific limitation.
It's whenever the chairperson calls the meetings and at any places and times as we deem necessary to do our job, right?
Yes, sir.
Okay.
Up through I would say up through when the next General Assembly is sworn in on the second Monday in January 2025.
So to that point, we're no longer in office. The biennial is over.
Yes, sir.
Might be in office if we're lucky enough to be reelected and have chosen to run, but otherwise it'll be a new General Assembly then.
Yes, sir.
Okay. Is it your legal opinion that we are authorized to conduct investigations and hold meetings and take binding actions up until, I guess that's the second Monday in January of 2025?
That would be when ultimately this committee disappears along with the 157th General Assembly itself.
Okay. And let me shift your attention a little bit to the resolution itself then. Because I'm looking at this as sort of three various grants of authority to this committee. Number one is this constitutional authority, whether specified precisely in the Constitution or just the implicit inherent powers that have been validated in the Dean and Bolton case, at least. Additional statutory powers under the statutes you've referenced, those would be not limiting, but in addition to this inherent or implicit power. Right.
Yes, sir.
And then the powers given under this Senate resolution that was passed and became law authorizing this committee.
Yes, sir.
Okay. In that, can I direct your attention to that resolution? It's in each person's folder as well. Okay. On page 3, starting at lines 45, I'll just read, whereas such inherent powers include the authority to create special committees for the purpose of conducting investigations and to endow such committees with all the inherent powers of investigation possessed by the Georgia Senate, including the power to compel the appearance and testimony of witnesses and the production of records and the power to place witnesses under oath or affirmation. Does that language specifically give us the power to subpoena witnesses to testify before this committee?
Yes, sir. It would appear to me that it does.
And to produce records for our investigation in the course of our duties?
Yes, sir. That paragraph does appear to be an explicit delegation of the Senate's inherent powers to this committee.
Is this in any way inconsistent with any statutory authority in Georgia or constitutional provisions in Georgia?
It is not contrary to any constitutional provision, and because it is the inherent power of the body arising from the Constitution, I don't believe a statutory provision could conflict with it.
Okay. The resolution goes on in lines 50 to 54 to say, in addition to such inherent powers, code sections 45-15-17 and 45-15-19 empower the General Assembly to make investigations into the affairs of the state and further authorize compelling the appearance and testimony of witnesses and the production of records, and grants the power to place witnesses under oath or affirmation and to enforce subpoenas issued pursuant hereto. Is this just an additional power to subpoena?
Yes, sir.
Okay, and that's what's contained in those two statutes?
Yes, sir.
Okay. Tell us about those two statutes.
Yes, sir. Again, 45-15-17 is the statute that grants investigative powers to the Attorney General that I talked about earlier, including the ability to subpoena witnesses and to compel the production of documents. It also does provide the procedures for enforcing those subpoenas, whereby if a person refuses to comply with the subpoena issued by the Attorney General is empowered to seek judicial enforcement of those subpoenas by going to the Superior Court of the county of the residency of the subject of the person to whom the subpoena was directed.
And does that statute give the legislative branch the same powers and authorities as the Attorney General?
OCGA 45-15-19 gives the General Assembly the same powers that the Attorney General has in 45-15-17.
So those powers of the Attorney General to subpoena and compel testimony or documents is granted to the General Assembly in 45. You got that?
15-19.
15-19.
Yes.
Okay. And that's recited in our resolution that formed this committee, that we possess those powers.
Yes, sir.
In addition to the power granted through the resolution itself, and in addition to our inherent constitutional powers.
Yes, sir.
So, okay. Do you have any question that this committee has the power to subpoena testimony or subpoena documents in furtherance of the duties set forth to this committee in the resolution 465?
No, sir.
Okay. Any other senators have questions? I want to recognize the minority party as our rules provide to ask any questions. And Senator Jones, I'll look to you since you've done that. Since this is more of a presentation than sworn testimony, since he's counsel for our committee, I'm going to defer to you. But then if other committee members have specific questions, unless there are objections, we'll do that. Right. You
I just-
you have the floor.
I
Let's
just
make
have
sure
one.
you lit up. All right.
And that was the 4 instances that you gave about them, I guess the committee doing an investigation after sign or die. Can you kind of go back into that a little bit more? And it was the last time that happened was in 1964. Is that correct?
Yes, sir. The last time that I'm aware of a committee being created, a committee being created specifically to investigate a specific part of the state government was the 1964 resolution that the Senate did regarding the Stone Mountain Association.
And obviously no one has never come up. So this would be a case of first impression, I guess.
Yes, sir.
If it goes to court. Have anyone given any legal opinion about why they may believe that they are not subject to subpoena? Like, what's the counter argument? I'm just curious.
My understand, they're people who have court, like in the Montana case, the court administrator did argue that the subpoena went beyond a legislative purpose. There are limitations that a legislative subpoena must be in furtherance of a legislative purpose, and so there are many instances where people have challenged a subpoena issued by a legislative body alleging that there is no legislative purpose behind this investigation.
And do you think that would apply in this case? Of course, we don't really know, do we?
The resolution, under my understanding of the resolution, is that it is designed for this committee to investigate potential legislation to be introduced regarding potential matters of appropriations regarding district attorneys, the contracting procedures, especially in regards, I think it specifically references hiring special prosecutors. So my understanding of the resolution is it does outline a legislative purpose for the committee.
Yeah, I think so. Thank you. That's all.
And doesn't it specifically direct us to investigate the conduct of District Attorney Willis's alleged conduct?
Yes, sir.
So it wouldn't be out of line to invite or to compel her to appear for this committee then, would it?
Not if this committee believes that is in furtherance of its legislative purposes.
Seems it's almost fair to give her a chance to defend herself and give her side of the story. Agreed or not?
I have no position on that, sir.
That's the lawyer answer. That's good. And that's what we pay y'all the big bucks for, is just give us impartial advice. Thank you. Other committee members with questions? Senator Tillery, I'll recognize you for the question.
Thank you, Mr. Chairman. Thank you, Mr. Morelli. I have one question. I heard you read the Dean opinion that talked about let it be sufficient to say the constitutional provision does not prohibit a person from the executive branch from investigating, or from the legislative branch from investigating. Then I want to go to that next paragraph though, because you've studied this more than we ever will. The sentence that said the General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. In your research, I understand where you've tied this up, but I want to look at the little hole here and say, have you in your research found any statutes or procedures that the General Assembly, since this decision, have enacted that would limit that power that you discussed that Dean appears to give?
Yes, sir. Actually, following the issuance of Dean, or almost concurrent potentially, the predecessor to OCGA 45-15-17 was amended in 1975. And one of the provisions added at that time, and I'm going to pull that was a subsection D to OCGA 48-15-17, which specifically provides that nothing within that code section shall authorize the Attorney General to investigate members of the General Assembly during session.
During session.
Yes, sir.
So if we carried that same provision over to 48-15-19, then
that statutory provision, of course, could not, but the Constitution does grant each chamber of the General Assembly the ability to, govern and investigate. There's an inherent and constitutional power of each chamber to govern the conduct of its members.
Gotcha. So that whole would not be able to eviscerate the power that it appears that we have through the Constitution and then through the progeny of Dean.
Correct.
Gotcha.
And further backed up by the provisions of the ethics provisions of Title 28, which were subsequently added much more, I think in, the early 2020s, the detailed ethics provisions that give a second independent statutory procedure for the ethics committees to issue subpoenas.
All right, other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA
Thank you, sir.
55, 15, 17, and 19. When were they adopted into law and by which governor was it signed?
I don't know which governor. They were initially enacted into law in, I do have that before me if you will give me a second. It was in the 1950s. I do know that much. I don't, I want to say 57. I don't know who the governor was.
Any stories behind the reason for the laws at the time?
My research did not delve that far. I've saw the statutes are on the books, and in preparing for today's meeting, I went and pulled when they were initially enacted, but I did not do any further research on what may have created them.
Thank you.
Caused them.
All right, I would advise all committee members that Mr. Morelli is available to all of us if you want him to follow up with any further cases or explanation or updates. You're all free to contact him directly. He is assigned to this committee as a resource to each committee member. The memorandum, I call it, they call it the manual on investigations and subpoenas was done back in 2016. We each have a copy of that in our folders, and it sounds like he's done some updated research. I just have one more question. We need to move on. That Supreme Court case, is it Mazars that you're saying?
Mazars.
Mazars. Is that one where the president was objecting to subpoenas from some congressional committee?
Yes, sir. A variety, I believe multiple committees of, I think it was the House. That was the case where they attempted to get his bank records. Mazars USA was one of the accounting firms, I believe, that personally worked for President Trump and his businesses. One of multiple, I believe, House committees attempted to obtain documents from them.
So they objected to the
President Trump objected to his bankers releasing the documents. So
did the Supreme Court force them to produce the documents in
the Supreme Court overturned it both. That I believe there were cases both before the DC, the U.S. District Court for the District of Columbia, and some in the Southern District of New York. Both of those trial court levels did go up to the relevant courts of appeal. Both the DC Circuit and I believe the Second Circuit upheld the subpoenas. The cases were merged before the U.S. Supreme Court, and the Supreme Court found that both the various courts of appeals and district courts did not sufficiently consider separation of powers issues relating to the president, remanded the matters back. I believe ultimately the various trial courts and courts of appeals allowed the committees to get some documents, but not as many as they had initially been seeking.
Yeah, and so the limitations on those subpoenas were due to the presidency, not other government agencies.
It was based upon the finding that a legislative subpoena on the president's personal documents so interfered with with the entirety of the federal executive branch, because under the unitary executive theory, the president is the executive branch.
So is this when they were trying to get his tax returns?
There is separate case law on that, that did go up. I believe they did get those. Those are based on statutory grounds.
Tax returns. Senator Dolezal, do you have a question?
I have just really one quick question. Mr. Morelli, would it be accurate to say that this February 26th document it essentially serves as a basis for the authority delegated to this committee in Senate Resolution 465?
I mean, it is intended, the reason I call it a manual is because it was intended by our office to be a guide to members and committees of the General Assembly on how to carry out investigations if they wished.
Is there anything that you've seen in Senate Resolution 465 that's in conflict with either the manual or anything that you have since discovered in your legal research, whether it be in Mason's or previous court precedent?
No, sir.
Thank you.
All right. Thank you for being with us.
Yes,
Don't
sir.
leave us, but go back to your role here behind the scenes, advising us and watching. And if you think of additional information or new cases come to light that you think will be educational to our committee, please present those to us along the way.
Yes, sir.
Okay. Former Secretary Cook, please come forward. So good to see you again. Thank you.
Now get out of your way. Do you want me? I mean,
No,
the chairman has dismissed me, but
you're not dismissed. You're just taken off the hot seat. If you want to sit up there, you're welcome to, because you guys are both just full of knowledge. That's good for us.
I'm going to go back to my preferred spot, hiding in the corner.
All righty. We do. We do. You'll raise your right hand. I'm going to swear you in before the committee. You swear the testimony you'll give before this committee will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right. Please state your name, your previous position, and tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I am the former Secretary of the Senate. I am received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. And the Dean case that you were talking about earlier, I remember very well. It was my first year as the reading clerk for the Georgia Senate when Roscoe Dean was tried on my birthday, January 27, 1977, in front of the Senate for a contempt proceeding. So I was kind of chuckling when that case came up. But I've been associated with the Senate in one way or another for a number of years. I was Secretary of the Senate for the last 11 years and retired at the end of last month.
In your role, you have been a great guide to the Senate and the Committee on Assignments and other senators that have had procedural questions and issues. And you've been a great help to me, providing me just binders full of information, especially on how investigations have been conducted by legislative branch at all levels of government. So I wanted you as sort of a subject matter expert to tell us your thoughts today. Just give us your preliminary reviews and talk to us about the power to investigate of the legislative bodies, the Senate in particular.
Good. Well, thank you. I think the question before the committee obviously is, does the committee have the authority to investigate, to subpoena witnesses, and to compel production of that testimony or of documents? And I am of the opinion that the Senate clearly, and that this committee clearly has that authority. I'm in agreement with counsel who just testified here. I think he did a good job of laying out the law regarding the power to investigate. I want to come at it more from a parliamentary law, parliamentary procedure standpoint, but there's no way to separate those two out. They are both intermingled. So Stuart may have some comments on what I may say, or I'm going to provide some of my understanding of what I think the law says. But I'd like to start to basically give you what I think is an analysis from the viewpoint of parliamentary law and procedure as to why this committee does have the authority to do the investigation, to subpoena witnesses, and to enforce those subpoenas. I would first touch on a few principles of parliamentary law and then move on to our rules of procedure, parliamentary authority that has been adopted by the Senate, and hopefully demonstrate that this committee was one properly created that the subject matter of the investigation is legitimate, that the committee has the power to meet during the interim, which we talked about a little bit, that the committee has the power to subpoena the testimony of government officials and to enforce those subpoenas. So before I begin on the parliamentary path, I think it's fundamental that we tip the hat to the 100 or more years of U.S. Supreme Court case law that says a legislative body has the power to investigate. I don't really know of any court that has said a legislative body does not have the power to investigate. There are some differences when you get down into other issues as, and do you have the power to subpoena? Do you have the power to compel that? And I think the contempt power of the Senate, for example, provides some limitations, but there are other avenues to enforce subpoenas as well. So I think the analysis Stuart gave regarding the inherent powers of the Senate is very important. It's what most everything that we're talking about today is based on. Mason's manual, which you referred to a little bit, is recognized as the modern day parliamentary procedure manual for state legislators and legislatures, and is for the Georgia Senate. It's actually interesting. There have been 3 iterations of this manual. The very first one was by Thomas Jefferson when the country was instituted, called Jefferson's Manual. And out of that arose Cushing's Manual, which was used in the 1850s. And in the early 1900s, the state of California, Paul Mason, developed a very robust manual of legislative procedure, and it evolved into what we have today as Mason's Manual of Legislative Procedure. It's the authoritative manual on parliamentary procedure for state legislatures.
Is this the one that the National Conference of State Legislatures has adopted?
That's correct.
Yeah.
California granted NCSL, National Conference of State Legislatures, the actual rights to this in the 1980s. And since then, NCSL, they have a committee of parliamentarians that sit on this, and they update it every decade. So the most recent edition is the one that was updated in 2020.
Tell the committee and the public that's listening to you what NCSL stands for, what that organization is.
NCSL stands for the National Conference of State Legislatures, and it is a national association that is comprised of, to my knowledge, every state legislative body in the United States. And it draws on the expertise of members of the legislature and staff to help the state legislatures perform their functions as legislative bodies.
Well, it just so happens that Senator Kennedy and myself were at their national convention this summer.
Mm-hmm.
And there was a session on, I believe it was titled, Everything You Want to Know About Legislative Subpoena Power. 3 different states had presenters, and all unanimously said their states had upheld the power of the legislature to do investigations and use subpoenas. It's funny that issue happened to be, addressed this year, but it was certainly reaffirming to us that all the states claim this power and exercise, and it's been upheld.
Right.
Back to Mason's.
Yeah. And to my knowledge, there's been the power to investigate is derived from the grant of legislative authority that has been given to the General Assembly by the Georgia Constitution. And everything kind of derives from that legislative power. The interesting thing about Masons, the good thing about it is that when you look at our rules, Senate Rule 10-1.5 provides that when any question that's not provided in our rules, which arises and not provided in these rules, the same shall be controlled by the most current edition of Mason's Manual. So the Georgia Senate has adopted by its own rules everything that's in Mason's manual. Obviously, there will be a few things that are a little inconsistent and where we are more specific on it. For example, there's some question about whether you can meet during the interim, but we have a Georgia constitutional provision that allows us to do that, which would override Mason's manual there. So we've adopted Mason's, and we'll be citing that throughout. Both, I think Stuart cited it, and I'll certainly be citing it. Before we get into the substance of the rules, I think it's important to touch on how rules of procedure are applied, and Mason's does a really good job on it right at the beginning of Mason's. In section 4, it puts it pretty succinctly. Mason says that the rules of parliamentary procedure are derived from several sources and take precedence in the order listed below. Those principal sources are, number one, any constitutional provisions. So if you're looking as to how the legislative body should act, constitutional provisions and judicial interpretations are paramount. The next authority are the rules of the Senate that we have adopted. The third authority is, what is our custom? What precedents have we had? How do we normally operate? And we have several ways that we operate that involve precedent and custom. Following that, in the level of authority, are statutory provisions. So in terms of procedure, our Senate rules can trump statutory provisions regarding procedure. Then the adopted parliamentary law, which is Mason's, and then fundamental parliamentary law, which really is pretty succinctly due process requirements that are required for any legislative body, and we're all lawyers are familiar with it, with due process in court, notice and opportunity to be heard, those kind of things. So Mason's is an important part of the Georgia Senate's parliamentary rules. I'd like to take just a minute to talk about committees, because that's what we're talking about here. There are really three types of committees. One are standing committees. They're provided for by our rule, section in Rule 2-1.3. And the purpose of standing committees is to look at issues that we know are going to be continuing. You have public safety, you have judiciary, you have government operations. We know that there are going to be all kinds of issues that occur during the session every year, year after year, that require the establishment of a standing committee to look at those issues. This committee is not a standing committee. The second type of issue, or committee rather, is conference committees, and those committees are created for the specific purpose of resolving differences between the houses. And you all are familiar with those on the last several days of the legislative session, where we have conference committees meet and work out disagreements between the House and Senate. And the third type of committee are called special committees. And special committees are created for the consideration of a specific task or duty, or to look at a specific issue, or to perform a specific function. These committees can also be named ad hoc, investigating, select, or study committees. We refer to them a lot as study committees here. And special committees are created by a resolution. Either by resolution, they can be created by a motion from the body. In this particular case, SR 465, the resolution that created this committee, was established by a vote of the Senate. Senate Rule 5-5.1 requires 29 votes to establish this committee and pass that resolution, and that occurred in the 2023 session. So the committee was appropriately established as a special committee of the Georgia Senate. So what are the committee powers? So the creation of a committee is authorized, as I said, by resolution. And I think it's clear, I've kind of refer to Mason's here a little bit and quote them. The Mason's provides that the legislature may proceed to make investigations with its authority by authorizing committee of one or both houses. So there's been some question of whether the Senate can act without the House, but Masons clearly says that either house can establish a committee for purposes of investigations. Masons also says that the right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. That's Mason's 7795-11. So the creation of the committee, I think, was done in accordance with statute, in accordance with rules, but it was also done in accordance with our precedents. And Stewart touched on one of those going back to 1871. I think I'm not familiar with that one, but I am quite familiar with the 1964 Senate resolution that created the Senate Committee to investigate the Stone Mountain Memorial Association's Senate Resolution 30. It's actually created during the special session of the Georgia Senate General Assembly in that year and issued a report back, I believe, in the next year. So the committee was, I think, properly established under our rules and under precedents. I think it's also important to note that committees have to be viewed as agencies of the creating body, that this committee is an agent of the Senate. And any committee can exercise only those powers that are delegated to it by the Senate. The corollary of that is that any powers that the Senate does delegate to the committee may be exercised as fully by the committee as it could by the Senate. There's U.S. Supreme Court case law on that, and certainly Masons provides the same thing, Masons 795-5. So the powers granted this committee are broad, and you touched on them earlier, and I think it's important to refer to the resolution. The resolution specifically gives this committee the power to investigate, and specifically in the resolution to investigate the office of the Fulton County District Attorney and the conduct of the Fulton County District Attorney. Mason's Chapter 74, is several pages long, goes on at length about the legitimate powers to investigate of a legislative body. And it's clear from our rules and precedent and case law that the subject area of this resolution is within the scope of the Senate's authority to do that investigation. For example, Masons provides that, quote, an investigation into the management of the various institutions of the state and the branches of the state government is at all times a legitimate function for the state legislature. The U.S. Supreme Court case that Stewart referred to, McGrain versus Dougherty, holds that an investigation into alleged malfeasance is, quote, plainly the subject on which legislation could be had and would be materially aided by the information which the investigation was calculated to elicit, end quote. The U.S. Supreme Court in Watkins versus U.S. said that Congress's power to investigate is at its peak when the subject is the alleged waste, fraud, abuse, or maladministration within a government department. That's Watkins versus U.S. 1957 case. So the subject matter, I think, of this investigation and the authority of the committee to do it, I think is appropriate. Second, the Senate specifically delegated to this committee the power to issue and to enforce subpoenas. The resolution states, quote, for the purpose of conducting an investigation as provided herein, the committee shall have the power to administer oaths, to call any party to testify under oath at such investigations, to require the attendance of witnesses, production of documents, books, records, and papers, and to take the deposition of witnesses. The resolution goes on further and says, for such purposes, the committee is authorized to issue subpoenas for any witness or to compel the production of books, papers, and records, and is further authorized to undertake such actions as may be necessary to enforce such subpoenas in case of refusal to obey. So I don't think there's any question at all that there's been a full grant of the Senate's inherent power to this committee to investigate and to do whatever it deems necessary and proper to compel the production of testimony and documents. Further, SR 465 specifically grants the committee the authority to meet at such places and times as it may be necessary or convenient to fully exercise and effectively use its powers to perform its duties and accomplish the objectives of the purposes of this resolution. It's line 82 of the resolution. I think this language, as we touched on earlier, is broad enough to include the authority to meet during the interim, which is specifically authorized by the Georgia Constitution. Finally, SR 465 specifically authorizes the committee the power to enforce its subpoenas. The resolution states that the committee is further authorized to undertake such actions as may be necessary to enforce such subpoenas in cases of refusal to obey. The lines 77 and 78 of the resolution. So I think this is an interesting area that people don't, the next area, which is how do we enforce subpoenas, is where people get sidetracked just a little bit. And there's a little bit of a nuance there. I think there are three areas or three methods by which the Senate, and by virtue of its delegation, this committee can enforce its subpoena powers. And the first is by contempt. And that is set out in the Georgia Constitution. And there are some Article 3, Section 4, Paragraph 8. I think there's some limitation in that constitutional provision when you're trying to enforce a subpoena by virtue of the contempt power that's set out. There are different ways to enforce subpoenas, but the contempt power is one. And I think the contempt power can only be used during a legislative session. And it gets into the nature of how does a legislative body use its inherent contempt power. They get the sergeant at arms and they issue an arrest warrant, and the sergeant at arms, which has been in some of the cases and some of the very first uses of the contempt power of a legislative body, they go and arrest. I think the first one was maybe the Secretary of Agriculture, and they arrested him and brought him before the bar of the Senate, tried him and held him in contempt and imprisoned him. But that power to enforce the testimony through contempt is for punishment. And that power of punishment only lasts as long as the session as we are in session. So once we adjourn sine die, we lose the power to punish for contempt. But there are two other ways to enforce subpoena powers. The second method is through a judicial enforcement of subpoena powers. And I think there's no question, Stuart can talk more about this better than I can, but if the Georgia Senate has the inherent power to do investigations and the inherent power to get witnesses and testimony and information in order to fully inform its legislative process, and that process is stymied or objected to or thwarted in any way, I think the Senate, and by virtue of delegation of its power, this committee can walk over to the Superior Court of Fulton County, seek an injunction in equity. Stuart touched on it, try to seek a declaratory judgment action and an injunction in order to enforce what is its inherent investigatory and subpoena powers. That's called judicial enforcement. So I would say that is the second manner of enforcing a subpoena. And the third manner is by statute. And Stuart laid out what we have is in the statute 45, 15, 17, and 19. I guess the only comment I would have there's there's this statute, there's a statute that authorizes the Ethics Committee to enforce subpoenas, et cetera. But the inherent power of the Senate and its ability to delegate that power to a committee is constitutional. I don't think anybody would disagree with that. And clearly statutes cannot overturn what is a constitutional power. So I think anytime you're reading a statute where it says the General Assembly, et cetera, that has to be interpreted as supplemental to what are inherent constitutional authorities of the Senate and of this committee. So those statutes, I think, should be viewed as supplementing what the Senate's powers are, not as restrictive of it. So those are my prepared comments today. I'm happy to try to answer any questions that you might have on this, and happy to hear from counsel on anything that I might have said from a legal perspective that he might disagree with.
Mr. Secretary, you were the secretary at the time we issued these subpoenas for Fani
Yes.
Willis. In your opinion, are they in compliance with Senate Resolution 465 within the scope permitted under that resolution?
Yes.
Anybody else have any questions for Mr. Cook? All right, thank you for being with. Wait, I do.
Oh, yep.
Senator Estevez, you're recognized.
Thank you, Mr.
Yeah,
Chairman.
sure.
And thank you, Mr. Cook, for laying this framework out. So my question is, are you aware of this power and even the enforcement procedures that you've laid out ever coming up before, used by this Senate body before?
And from a legal standpoint, I'm not aware of any, and Stuart, I think, can get more into that than I am. I'm not aware of. I think they're in the Dean case. There were several aspects of that, including a trial for a criminal trial. And there was a contempt proceeding in the Georgia Senate on that. And I think there were subpoenas issued pursuant to that, but I'm not sure. That would have been the only case. And then Stuart mentioned one, I think that subpoenas were issued back in the 1800s, but those would be the only cases that I'm aware of.
So 150 years ago, and then in proceedings against one of our own members.
Mhm.
Okay. Thank you.
Right, thank you very much. Appreciate you being with us this morning and all your service to the Senate for many, many years. The last person on our agenda, of course, is the first person, Honorable Fani Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
Mr. Chairman.
Yeah. All right, thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce the documents requested by our subpoena for the production of documents. At this time, I want to let the committee know that we have hired Mr. Josh Belafonte to assist us in our legal enforcement efforts on the subpoena. And I would like for us to have an opportunity to be briefed by him. We have privileged communications with him under the attorney-client privilege. Our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation
Don't go away.
stands,
Question
now
and
would be
answer
the
coming up.
time to move for that. I recognize Senator Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.
All right, there you have it. That's the public proceedings before the Special Investigative Committee of the Georgia Senate. They are going into executive session, which means it's in private. They're going to have their lawyer with them. And of course, when you talk to your lawyer, it needs to be in private. So that makes perfectly good sense. Why do they have a lawyer? Why does this Senate, you heard from a couple of lawyers, including the Legislative Council. That's the person there that generally advises the legislature, both the House and the Senate and the committees here in the Georgia legislature. But they have their own lawyer for litigation. So what kind of litigation are we talking about? Well, the district attorney herself, Fani Willis, has hired former Georgia Governor Roy Barnes, and she's filed a motion in the Fulton County Superior Court to quash that subpoena. She wants to shut it down. She wants to not appear. We've seen this before from her. We saw that she moved mountains to not testify in the Nathan Wade divorce case. For those of you who've been following along for quite a while now, this goes way back to the early days of when Ashley Merchant sort of unearthed and revealed the affair, the whatever you call it, with Nathan Wade, her former special counsel in the Donald Trump RICO prosecution in Fulton County. So she's not done anything to answer questions about this. What she does do is she goes to the local churches and the fairgrounds during her campaign, and she makes statements sometimes in very, very friendly in front of friendly audiences, and she calls people liars, and she calls Ashley Merchant a liar, and she talks poorly in public about the defendants, but she will not answer questions about what's going on. She won't turn over records. Ashley Merchant has sued for open records, and we've covered that here inside the law. And Ashley just told me a few moments ago that there's now a motion filed by Fani Willis to recuse Judge Krause, who is the judge in the in Ashley's open records case. So she's now, because that judge issued some rulings that were adverse to Fani Willis, so now Willis wants to get rid of that judge. She didn't want to get rid of the judge who had the illegal ex partes in the YSL case, but she wants to get rid of Judge Krause, who is the judge who actually disqualified Judge Glanville because of the ex partes, and who is ruling against Willis so far in the open records lawsuit. Okay. So I've got a copy of the motion just filed today. It's very long. Ashley sent it to me, but it's very long, and it's the motion to disqualify Judge Krause. I haven't read it. I haven't digested it, but I'm going to do a live stream on it. You can count on that. You can also count on the live stream about the order issued yesterday in this racketeering case, where a number of charges were dismissed, a couple of those charges applicable to former President Trump. I got a copy of that order. It's also long. I've got to digest it. I'm going to be doing live streams in coming days on those things. So make sure you subscribe to Inside the Law so you get the notifications. All right. Back to what we just saw. All right. So this was the time when Willis herself was issued a lawful subpoena. You heard from the Legislative Council, and you heard from the former Secretary of the Senate, who apparently testified. Apparently, he's just recently stepped down from that role. He was the Secretary of the Senate. He said when this subpoena was issued, and those gentlemen are subject matter experts. They're very well qualified in the procedures, and the laws that govern how these committees and the legislature operate. There's no question that they have the subpoena power. People have asked me to summarize the testimony. It's real simple. They have the power to issue this subpoena. They have the power to enforce this subpoena. What does that enforcement action look like? We're going to have to wait and see, because that's what they are talking about right now in executive session, probably with their attorney that they have hired to represent them in the litigation. And it's now litigation caused by Willis when she has essentially sued them in the motion to quash their subpoena. So now they have to litigate that issue. We don't have a judge yet, because all of the judges in Fulton County have recused themselves from hearing the motion to quash. It was filed in Fulton County because that's where the legislature sits. It's in Fulton County. It's the seat of the state government. So now that all of those judges have recused themselves, some other judge from another county, and we don't know who, will be assigned to rule on that. But as we sit here today, as we're talking, and it's 11:44 a.m. local time in Atlanta on Friday the 13th of September, Fani Willis is in violation of her subpoena. So she has completely blown it off. Imagine what would happen if one of the YSL witnesses subpoenaed by the state just decided they didn't want to show up. Fani Willis would have the sheriff pulling that person into court in handcuffs and leg irons if necessary to force them to testify. But she, who says everybody is above the law, believes that she doesn't have to comply. She doesn't even have to have her lawyer show up there today and do them the courtesy of saying, my client's not going to be here because we think the subpoena is unlawful. She doesn't have the decency to show up and say, I'm taking the fifth or anything else, because I don't think we're going to wait. She wants to wait until there's a ruling, but look, she's missed her boat, right? The chance to be there was today. She missed it. They're going to have to seek to enforce that subpoena. And when they do, the courts are going to obviously be involved. And I don't know where this is going to go. We're in uncharted territory here. But why? Because this kind of thing just doesn't happen. The chairman of the county commission showed up. He answered questions. I think it was voluntarily. They didn't have to subpoena him. I'm sure he had other things to do. He's the head of the county government, basically. He's head of their commission anyway. And he showed up and he answered questions about budgeting and everything else. People say, well, this is partisan. This is a Republican-controlled committee. Well, the Chairman Pitts is a Democrat. Just because you're in another party doesn't mean you shouldn't cooperate with the legislature. That's how government functions. So she's not there. All right. So I'm very, very humbled by the currently 3,400, almost 3,500 people that are here. At one time, we had a little over 4,000. I'm very humbled that you would spend part of your day with me here inside the law. Of course, this is your LawTube channel where we take you inside the real justice system. Now, is this the justice system? Is this this is a Senate committee, but the reason it relates to the subject matter of this channel, first off, it's a supplement to something we've been very deeply involved here inside the law, which is the Fani Willis racketeering case. But also, the legislature makes the laws that govern the courts. They make the laws that the criminal laws. They make the rules of evidence. They create the rules of procedure. Well, not entirely. The Supreme Court gets involved in that as well. But the legislature, has a big, big role to play in how the justice system operates. And they have it within their power to investigate how district attorneys do their work, because up until very recently, there's been little to no oversight to rein in district attorneys who either failed to do their job or who did their job in some kind of crazy wackadoo way that leads us to where we are today. Okay. So that's why this is important, and that's why it's relevant. I want to say that the chat has been very active, and I have done my best to try to flag some questions and some comments. And I promised you a Q&A, so let's just dive into it. And some of this is just things that I may have already covered. So right at the top, this is just in the order that the super chats and other things came in. And by the way, thank you so much for the super chats and the other support, because that's what helps me bring you this content. This is what allows me to put my day job on hold and come here and do this kind of thing so we can hopefully learn something along the way. Melody asks, can Fani be held in contempt? I think the answer is yes. I think she should be held in contempt, and I think that's where this is going. I think they're going to hold her in contempt. But then the question comes, okay, once she's in contempt, what does that really mean? So, like we've seen at the federal level, we've seen individuals recently that have been found to be contempt of Congress on the federal level, and then it's up to the Attorney General of the United States to decide whether they want to prosecute them. So holding her in contempt, they don't have the direct authority to jail her. They're not a court. So the question is, and that's what they're discussing with their lawyer, if they hold her in contempt, what does it mean? What's the remedy? And I can promise you they're going to do everything that they can to try to compel her to testify and answer questions and produce documents. And look, I certainly hope that the shredder at her house or her office is inactive. I hope she's not destroying these documents, these records, these emails, these texts, and the other things that they're trying to get, because that's what they really need. They need to understand why and how this whole sordid affair came to pass. All right. Thank you very much, Melody, for that super chat. Next, we have similar, and thank you, Great Grandma Anon. Thank you for that super chat. Can Fani be arrested if she doesn't show up, such as with Bannon and Navarro? That's kind of what I was just talking about. That remains to be seen, and that's going to be some of the subject of this litigation that we have now over the validity of the subpoena. Thank you very much, but we're just going to have to stay tuned and see what happens. At the beginning of this show, this stream today, before the committee started, we had the vice chairman, Senator Dolezal, came here inside the law. He spent 2 or 3 or 4 minutes explaining what they are trying to do. Okay. And I know, if I know him, I know that he and this committee are determined to get what they're after, and they will do everything that they legally can do to enforce this subpoena. In case you can hear what's going on in the background, you have the executive producer of the show. There's Winston. He's keeping me safe from someone or maybe a leaf falling on the ceiling. So there you go. Winston's barking. All right. So what is my honest prediction on the outcomes? Well, there's a lot of different outcomes. I mean, which I think she's going to get removed. The oral argument that Ashley and them are going to make in the Court of Appeals on her disqualification is in December. So we got a couple of months to go. But I think, and I did a live stream on this where I discussed the judges that are on the Court of Appeals that are hearing this. I predict that they are going to be, they being the Fulton DA's office, I believe they're going to be recused from the whole shebang. And if that happens, well, the indictment is probably going to die on the vine, because I don't think they're going to find another prosecutor able or willing, quite frankly, to take up the torch and run with it. So I think that's going to be the ultimate outcome. Thank you for the super chat, and thank you for the question. And by the way, thank you to Republic Room and all the members of the channel who have subscribed for membership. Thank you very much. So thank you. Thank you for the comment. Look, the question here is why would she defy the subpoena if she's done nothing wrong? And I think that's a valid question. I think it's a good point. I personally think that if she has nothing to hide, thank you for the super chat, by the way, and the question. If she has nothing to hide, why would she not be there? And she'll say, "Oh, well, I'm just defending my office. My office is separate. I'm a constitutional officer, and y'all don't have the power to drag me in." Well, they do. The Constitution says they have the subpoena power to do it. State law says they have the ability to do it. I'm convinced they have the ability to do it, but she's going to say something like that. She's never going to admit that she's done anything wrong, but thank you very much. Simply HR, thank you for the super sticker. Thank you for subscribing. And yes, I mean, I think we have one of the best chats in LawTube. I think I really, really am impressed with our chats, and I like to keep those chats available during the replay, unless I've got to do any kind of post-production editing. That live chat should be there on replay, and I go back and watch it because I miss a lot of it. But I do love the live chat here inside the law, and thank you for the subscription. And by the way, I'm approaching 50,000 subscribers. So if you know anybody else that might like this kind of content, by all means, bring them in, introduce them here. Thank you again, Simply HR, for this super chat. So you referenced that DEI initiatives target a culture shift towards comprehensive inclusion and equity. I think you were answering maybe somebody else's question about what that is. I'm not going to get into, things that are political hot buttons too much, like DEI. And I know that a lot of people have very strong feelings about that. And I'll just leave you folks to chat about it amongst yourselves. I don't need to weigh in on that piece of it, except you point out that Title VII is a legal protection, and DEI initiatives target awareness and acceptance. Thank you for that clarification. I think you were responding to someone who is who had a question in there, and thank you very much for the super chat. I will let you all express yourselves amongst yourselves regarding other things related to that topic, but thank you very much. Jeffrey Jordan, they need to arrest her and her lawyer, or it will continue. I think she's untouchable because she has the ex-governor as her lawyer. Well, I think she hired the former governor certainly because maybe for appearance's sake, he's got some kind of gravitas, but he's not been the governor in many, many years. He's a practicing attorney. I actually see Roy Barnes walking around in or around the courthouse sometimes near where I practice. He's a local attorney that I see around just like many, many others. But I would imagine he's probably approaching retirement if he's not getting ready to, but he still has his finger in the practice of law, and he's got a law firm. He also was present at one of these other hearings, and he also testified in the hearing, by the way, the hearing that took place in Fulton Superior Court on disqualification. He was one of Willis's witnesses there. So that's why she apparently has hired him. There's obviously some type of friendship or other pre-existing relationship, and by that I mean that they know one another, and so she decided to hire him. There's no need to arrest a lawyer for taking a client and pushing a position, but in terms of arrest, a committee does not have the power to arrest anybody. They don't have that. They're not the police. They're not courts that have the sort of the summary contempt power to say, I'm going to put you in jail for, how you're acting in my courtroom or whatever. They don't have that direct authority. They're going to have to appeal to a court who does have that authority if they want to try to jail her. I don't think they're trying to jail her. Maybe they are, but I think that what they're trying to do is get the information from her to force her compliance with this subpoena. That's what it's all about. Thank you, Jeffrey Jordan, for the super chat and for the comment. Let's see. Thank you again for another super. Simply HR. Why is Roy Barnes representing Willis? Is there a political agenda? Well, I think I answered the question about Barnes just a minute ago. Is there a political agenda? Hell yeah, there's a political agenda. I mean, that's been obvious for day one. This is obviously, in my opinion, a political type thing ironically, it was designed to sort of enhance Willis's standing on the national stage. I think maybe, and I'm guessing, I don't know this, but I'm speculating that she may have had her eye on higher public office, maybe in the state of Georgia, maybe in the next presidential administration, if things go her way. I don't know. But ironically, I think that all of this, because of the way it's been mishandled, in my opinion, has done exactly the opposite for her standing on the state and national stage. Thank you very much for the super chat. How is it that Willis believes she is untouchable to every entity in Georgia? I wish I knew. J. Eller, I wish I knew. I don't know. What do y'all think? Tell me in the chat what you think. How does she believe no one is above the law or except her? That's a great question. Again, I don't have the answer to it. It's probably a rhetorical question, but it's certainly one worth asking. Thank you for the question and thank you for the super chat. This is a sticker from Nana Bear 61. I'm sorry, I don't have my glasses. I thought it might be split. Thank you very much for the sticker. Our moderator, one of our great moderators, Kiana Shaw, has gifted 10 Inside the Law memberships. Thank you very much, Kiana. The memberships, these supers, this is what allows me to bring you this content. Sri is now a member for 5 months. I can't believe I've been doing this for more than 5 months, but I've been very, very humbled by the support, and thank you for your continued support, Sri. Allie G, thank you for the super chat. Fani is speaking at a women's event in D.C. today. I did not know that, but that's certainly not where she's supposed to be now, is it? She's supposed to be in that Senate room answering questions and following the law that, she said that nobody's above the law. So why is she in D.C.? Thank you very much for the support. And yes, thank you for pointing out the moderators. Look, this is the mods that we have in here are awesome. Thank you to all of you. And thank you for mentioning them, Allie. So look, thank you for the super chat. I mean, look, I say this, I have always said with regard to this particular racketeering case, I don't get it. We're not getting into who may be guilty or not guilty. This is about the fairness of the process. And this is about due process. This is about separation of power. This is about all kinds of things. And as we'll see in a future live stream yesterday in the judge's order, where he tossed a couple of counts, he indicated he might be willing to consider tossing some other things or maybe the indictment as a whole, because he's apparently interested in the presidential immunity issue coming out of the Supreme Court. So we're not getting into, at least I'm not. You guys feel free to get into all you want. This is a free speech safe space. This is all, I welcome opinions of all variety here. This is a free speech safe zone. It matters, though, who prosecutes, because when anybody is prosecuted, whether it's me, whether it's any of you, whether it's the former president or anybody, it matters that prosecutors do so with honesty and integrity, and that they follow the law and they don't engage in underhandedness. They don't engage in things that are illegal, that they don't withhold evidence like we've seen in some other cases from her office, exculpatory evidence. That's why it matters, because if you don't have a fair process and a fair trial, then our justice system will not and cannot work. There will be no, and I mean zero, confidence in anybody's confidence in the outcome. We have this case involving the indictment of a former president of the United States, and regardless of whatever happens in the election, historians 5, 10, 15, 20, 50, 100 years from now are going to look back on this. And if it's not been done fairly, and if people who operate unfairly are not held to account, history will look back and laugh at this, and laugh at us, and laugh at this period of time, laugh at our justice system. So that's why it matters who the prosecutor is. But thank you very much for the comment, and I'm sure it's going to spark some additional discussion in the chat. But thank you very much, and of course, thank you for the super chat. There was some additional questions. I want to go back and things that I pointed out. Coco, one of our mods, points out that nobody has done this, right? One of the questions that came up during this testimony is like, what kind of precedent is there? Well, it's like unprecedented. Okay. It's never happened that like a DA just blows off a subpoena. Okay. It's never happened that the Senate has had to investigate a district attorney for all this stuff. This is all brand new. And Coco makes a very, very good point with that. Similar to John's point here. Nobody's had the audacity to disregard polite requests to attend and to answer questions. It just doesn't happen. This was something you guys had talked about my dog. As I know this is off topic, but you've heard Winston in here before. You don't see him much. He's over my shoulder here in the picture frame, but people have always asked to see Winston, and I can't get him on camera. So I decided I would show you guys a couple of questions. I call him my executive producer because he's always in here with me when I stream, and he loves it in here, and he's usually right here at my feet. And anytime there's a sound elsewhere in the building, he goes nuts. He's not a vicious dog. I call him an alert or an alarm dog. He's not, he wouldn't hurt anybody, but if you heard him barking, you might think that he was capable of doing that. Got another super here. Fani skips her subpoena to speak at a DC event. Harris skipped Netanyahu's speech in DC to attend a sorority event. Do we see a pattern? Again, thank you, by the way, very much for the super. I'll leave you guys to discuss. I don't need to answer that. That's a question for you all to discuss amongst yourselves. I don't mind a little politics in the discussion. I just think I'm not, for the most part, going to weigh in on these things. I leave that to you all. But again, this is a free speech zone, and I welcome your free speech as well, regardless of, there's obviously a little bit of limits here. We got to maintain some couth and decorum here, but you guys are the best, and I don't see that ever being much of a problem here inside the law. All right. Look, so that's what I've got today. We've been here for 2 hours and 21 minutes here inside the law. Just to recap, what I've got coming up for you guys is some of this.
Ain't nothing more powerful than the odor of mendacity.
Right, so what I mean by that is we've got Fani Willis and she's trying to, there he goes. Hey, Winston. So we've got her trying to get rid of the judge who is ruling against her in Ashley Merchant's lawsuit. So that she's filed a very long motion to quash, and I guess I've got some reading to do later or at some point. I'm going to get into that. I don't know if it's going to be tomorrow or the next day, but as soon as I can get it put together, I got some pre-production work to do. I also want to do another stream related to the order that the judge signed yesterday that tossed a couple of counts. It had to do with two of the defendants whose cases were not stayed by the state court of appeals, but it does have application to President Trump. And so, thanks. I think Kiana's helping me. She said she's going to help me work on some emojis. I'm the most tech unsavvy person ever. But I agree. We do need some kind of a Winston emoji in here. We're going to do a show about that. And I don't know if it's going to be tomorrow or the next day, but if you subscribe to the channel, if you haven't subscribed to the channel, make sure your notifications are turned on. You'll see a notification as soon as I set it up. Sometimes I set these up same day, and oftentimes it's the day before, but you should get a notice. So thank you all very much. So that's kind of what we got coming up, is some things directly related to the Trump RICO case, and also the related but different civil case where Ashley Merchant and her law firm has sued Willis for open records violations. All right, I'm going to have to leave it there. For those of you who are interested, I'm going to pop over to Eric Hunley's channel. He's got a bunch of lawyers talking about things, and I'm going to pop in over there and say hi. But then we're going to get ready for the rest of the streams for the weekend. So thanks to all of you for being here. Thanks for your support. And I look forward to seeing you right here next time inside the law.